Good morning. Happy Friday. We made it to Friday, folks. So, a couple interesting things happened yesterday. Minor characters in the First Amendment auditing movement. You could only barely call them members of it. They're more adjacent to it. The first case involved Regan Benson. Apparently, she published the address, maybe the phone number too. I'm not entirely sure of the details of a cop. And there is a law in Colorado that you can't do that. And one of the things I mentioned the other day with Chili trying to get the addresses and phone numbers of the cops in his DeCastro versus Doe case is that generally speaking, there's a lot of protection on stuff like that in all the states that I've seen. They just don't give out the addresses and phone numbers of cops willy-nilly because, there's a certain segment of the population, violent criminals, who might, want to take retribution on the cops that arrested them and or the cops' families, etc. And so the state has a vested interest, a pretty big interest in making sure that people can't easily assault or interfere with the cops and their families in their private lives. That's why a lot of times, cops give just like a name. They don't give their full name. If you ask them, I'm Corporal so-and-so, but they like I'm Corporal Smith, but they don't say their full name or anything like that. I mean, they appear on police reports. The full name of the arresting officer usually appears on police reports, but that's neither here nor there. And on the stand, obviously, they give their full name. So I watched maybe like 5 minutes here and 5 minutes there. I watched probably about a total of 10 minutes of near the end of the trial before everybody rested. And once the judge started giving jury instructions, well, I tuned out because I had other things to do. But apparently it came back as a guilty verdict. Now, in the comments, because I was mostly just amused at the comments, there were a lot of Regan Benson supporters in there. And for the record, I would have preferred to see her found not guilty. I mean, I'm not entirely sure of all the facts of the case or anything like that. I don't really care. But generally speaking, I don't like it when people get convicted of crimes. I mean, if they did it, then fine. But, all things being equal, I'd rather see 10 guilty people go free than one innocent man hanged. And anyway, so there was a lot of support for Regan Benson in there. And first of all, the legal advice they were giving was just pure shit. She has freedom of speech. Well, all of the rights secured for us in the Bill of Rights are limited. They all have their edges. They're not universal. They are contained within sets of decisions by the Supreme Court and various other courts that limit those rights. And if the state has a significant or overwhelming interest in protecting certain rights, then they can in general limit those rights. So just saying I have freedom of speech is a meaningless statement. You have freedom of speech, but it is within limits. I also saw the whole shouting fire in a crowded theater. That is not good law. You can shout fire in a crowded theater. There may be repercussions for it, like if you do it and you incite a mass panic and people hurt themselves, you may have some culpability. But just the act of shouting fire in a crowded theater, like in the middle of a play, free speech. I've also seen various speakers shout fire in a crowded theater to prove a point. And again, it's not just like it. It's always more complicated than people think. Everybody tries to boil it down to these hard, bright line rules, and it's It's never that simple. Another weird thing that I kept seeing was that, she's never going to get a fair trial because the judge is prejudiced against her and the attorneys are prejudiced against her. And, well, that's partly correct. The prosecutor is obviously prejudiced against her. He thinks that she committed a crime, or else he wouldn't be bringing charges. He wouldn't be wasting valuable time and resources. Prosecutor offices are overwhelmed. That's why most cases result in a plea deal, not because the prosecution can't prove its case, but because they've got a lot of other cases, and if they're going to spend a lot of court time, they want to do it on a bigger, more meaningful case than, a misdemeanor or something like that. And so the prosecutor's definitely prejudiced against her, and he's supposed to be. We have an adversarial system. I 100% believe that her attorney was not prejudiced against her. Her attorney may believe that the state can prove its case, and if the facts are what the facts are, there's not a lot you could do with what the facts are. But what you can do as a defense attorney, if your client is unwilling to accept a plea, is to try to elicit information and elicit facts that might reduce the sentencing, that might cast some doubt onto the mens rea element of it, or something along those lines. So I am almost entirely certain that her attorney was not biased against her. I didn't see anything from the judge that would lead me to believe that he was biased against either party. Both attorneys get together and come up with mutually agreeable jury instructions. And if they can't come to an agreement, the court will decide which between the two. But the court is going to give jury instructions that are in line with the law. Because if he doesn't, that's an appealable issue. And most judges don't like to be successfully appealed. Judges get appealed all the time. Most appeals aren't successful. Judges, in my experience, typically have their eyes on getting into a higher position, like onto the Court of Appeals, maybe Supreme Court of their state. Maybe they're looking at a federal judgeship, and you don't get those if you get overturned on appeal regularly. So the judge is going to give jury instructions in line with what the law is, and the judge is going to make rulings on various motions and objections based on what that judge thinks the law is, because, again, the judge has a vested interest in not being overturned on appeal. And if the judge is actually biased, Florida has they televise their judicial reprimands and sanctions and whatnot. So their Supreme Court sessions where they admonish and publicly reprimand and suspend and sanction and disbar, those are published. And if a judge is actually biased, that judge can be removed, can literally be disrobed, I think is what they call it. Lose his ability not only to be a judge, but to practice law. It's basically a career-ending issue. So I understand that some judges are biased. I understand that. But that is the exception to the rule. That's not the rule. The rule is the judge is unbiased. The judge might look at the facts and have his own opinion on guilt or innocence, but he still has to be unbiased. He still has to give the jury instructions that if both sides have agreed to a jury instruction, that's what he's going to give, unless it's clearly outside of what the law requires. But the biggest issue that I have a huge problem with is, first of all, there's two big issues. First of all, there's a jury of your peers. If random Joe citizen listens to the evidence, listens to the explanation of the law by the judge, and finds you guilty, who cares if the judge thought you were guilty? The judge didn't say you were guilty. The judge just gave jury instructions, and the jury instructions either comport with the law or give you grounds for appeal. The jury itself is designed to prevent biased judges from ruling on matters. So if you think the judge is biased, ask for a jury trial and let your peers decide your guilt or innocence. It doesn't mean you'll win. You got to remember that, a lot of these things, they're actually violations of the law. That's why you get found guilty. But the other thing is they seem to think that you don't win at trial, you have to win on appeal. The courts of appeal use the same law as the trial court judges do, because the trial court judges are required to follow the law as it is explained or understood by the court of appeal. So the trial court is following the Court of Appeal's understanding of the law. So if you get to the Court of Appeal, they're going to say 90 times out of 100, but the vast majority of time, the Court of Appeal is going to say the lower court followed the law. And in these areas, they had discretion to do what they did, blah, blah, blah. I mean, it is hard to win on appeal. If your strategy is to lose a trial and try to win on appeal, that is a terrible strategy. Terrible strategy. If it was a good strategy, lawyers would use it, and they don't. Why? Because the lawyers understand the law. They understand their odds of winning at trial are significantly higher than their odds of winning on appeal. And you have to go through the trial to lay the ground record for any appealable issues. And even if you have good appeal, I still think Earl Warden had excellent grounds for appeal, and he still lost. And he's probably going to continue losing if he petitions federal court for review and for relief. But he had about the best grounds for appeal I've seen on a criminal case in a long time. I don't watch a lot of criminal cases, but and I certainly haven't participated in very many. And the ones I have participated in have all resulted in agreements, either the DA dismissing the charges or a plea bargain. So, it's a terrible terrible strategy to just give up and lose at trial. I mean, you're seeing right now what happened to Common Joe, where he basically abandoned the trial, and now he's trying to get a new trial, not even to get a new trial, but just to be able to appeal. And again, the escapee doctrine is going to prevent him from doing that until he's in custody. So just bad legal advice, bad understanding of the law, attributing bias to a proceeding where there's a jury that doesn't know anything about Regan Benson and is making their finding of guilt based solely upon the facts and evidence presented in court by both the prosecution and by Regan Benson. I did think it was an excellent tactic on Regan Benson's part to wear the U.S. flag shirt, a subtle nod to Afro Man. I don't know if she came up with it or her attorney came up with it or if it was just a random coincidence, but I thought that was an excellent nod towards Afro Man, where you could make an argument that they were both related to free speech, and they both felt that they were hard done by the police. So I thought that was an excellent trial strategy by the defense or whoever came up with it, if someone actually thought it through. Which leads me to Pulliam. Pulliam got a $75,000 judgment. He prevailed on two issues. One where I think it was the chief of police trespassed him from a media conference, a media brief. He couldn't prove damages on that one, though. No damages. Everybody overlooks damages. They see the wrong. They did this wrong, but what are your damages? Like that was the thing that I kept screaming about on DeCastro versus LVMPD. Like, you can't prove damages. Like, where are your damages? So, and also he couldn't prove the punitive damages against the chief of police, because the chief of police actions and his subsequent actions showed that it wasn't a trend. There was nothing prior to this interaction. There was only stuff post it, and the chief basically admitted that he screwed up. and he implemented policies in the police office, the department, whatever, maybe it was a sheriff, I don't know. That's an immaterial fact. I don't care about it. But he implemented policies, like he added Pulliam to the list of approved media, blah, blah, blah. And so no punitive damages, no damages proved, so he got nothing for that. But there was another cause of action against another cop, same chief of police or sheriff or whatever, where there was an incident that was not a high threat incident, and that cop excluded Justin. He let a couple social workers stay, but he tried to exclude Justin from the scene, and then arrested him for it. Now, cops can make mistakes, just like the police chief made a mistake. But this cop, unlike the police chief, doubled down. He screwed up, but then in his report, he phrased everything in such a way that it was a very misleading articulation of what happened. And then at trial, he lied about it. He said X happened, and then the attorney played a video that contradicted what he said, and then he said, oh yeah, well, I guess Y actually happened. Because of what that cop did, Justin got $75,000. Now, in my humble opinion, that cop should no longer be a cop. I'm okay with a cop making a mistake. Cops make mistakes all the time. We're human. We are never going to have a society where cops don't make mistakes, because cops are people and people make mistakes. So I don't really fault him for that initial interaction. But as a society, can we have cops that lie on police reports, that lie on the stand, both under penalty of perjury? That to me is a great wrong. And Pulliam earned his $75,000 on that. So congratulations to you, Pulliam. And then let's circle back to all those commenters in Regan Benson's case where the judges are biased and the attorneys are biased. Well, Pulliam got an award. Square that circle for me. How are judges biased and how are all attorneys biased if Pulliam got an award, a damages award, after trial? This wasn't a settlement. All the facts were laid out. It was a bench trial too. So it wasn't a jury. This was a judge who found liability, and a judge who found what the damages were. Where's the bias? All you retards out there, the system's biased against us, it just wants to protect itself. A judge awarded damages to Pulliam, who the judge laid out in the facts about how he's an agitator and how, he's basically a terrible person who tries to incite the cops and who says shitty things to the cops and who's just an all-around terrible person, which is a very accurate statement, I think, because I think Justin Pulliam is a terrible person. And despite that, the judge awarded him $75,000. Square that circle for me, if you can. That's all I got for you today. Thanks for watching. Have a great day.